Merci beaucoup, Anne-Marie. I'd now invite Richard Johnstone to come and talk to us about regulating health and safety in fissured work arrangements.
Well, good afternoon, everybody. Before I start, I'd just like to express my appreciation to a few people. Firstly, to Catherine Lapel for including me amongst the group of old researchers who are going to be replaced by a dynamic group of emerging and, I should say, judged based on what I've seen in the last few days, fully emerged researchers. And secondly, I'd just like to say thank you to the local organising committee, which I better put my glasses on because I want to refer to name. It's Catherine, Rachel, Maud, Renee and Sandra. And third, can I thank the interpreters who I think have done a fantastic job. And who I must not displease by talking too fast. So what I'm going to talk about today is I'm going to talk about the Australian model, but I want to do it in the context of supply chains, and that's because I'm working on a supply chain grant, and there's so little happening, in fact, within the work health and safety regulators that I'm going to use this opportunity to say what should happen, if I may. It does work. Okay, so what I have to race through without annoying the interpreters is what are supply chains and hazards from supply chains, and I'll do that very quickly. And for those of you who don't like the speed I did it, it'll be in my PowerPoints. There's about 10 PowerPoints covering those issues. And then I'm going to talk about the way that the new Australian model, essentially. And then I'm going to talk about what should be happening in enforcing the new Australian model in relation to supply chains. And I'm going to plagiarise heavily from David Weil's wonderful work on strategic enforcement. Okay, so first thing I need to do is explain what a supply chain is. And I've just got a picture there of a supply chain. It's an interconnected series of contracts for supplying goods or services to organisations at the apex of supply chains. So at the top you've got an effective business controller, as my colleague Igor Nossa always says, and below that head contractors, contractors, subcontractors, and because it's a contractual chain you can have any configuration. But at the bottom you'll all notice there's a worker. I'm going to race over the next few slides, but the point I want to make in this one is that supply chains are increasingly found in a whole number of industries. The two that I'm particularly interested in at the moment are road transport and manufacturing, particularly textile, clothing and footwear. But you'll see from the PowerPoint that there are a whole number of industries, and that list I got from Michael Quinlan's work in 2011, so I'm sure it's even longer now. This is the supply chain in textile, clothing and footwear. So at the top you've got the retailer, effective business controller. Then below that you've got fashion houses and principal manufacturers of clothes. They outsource production to suppliers and makers who in turn outsource production to home-based workers. And in long-haul transport, again, at the top you've got retailers, for example. Doesn't have to be retailers, but it's the effective business controller. But below that, the transport operator. And then you can have a series of contracts before it reaches the owner-driver. And again, these are all contractual chains, so the chains look different, but these are two typical supply chains. Now, these are examples of what David Weil calls fissured work arrangements. And that's the situation where large organisations, lead businesses, shared non-core labour tasks to a complicated network of smaller business units. So typical arrangements, fissured arrangements, are supply chains, franchise arrangements and subcontracting. And so wage setting, supervision and hopefully from the perspective of the lead business, work health and safety shift from the lead businesses to these smaller business units, and the difficulty that arises is that these smaller business units are working within a much more competitive environment, and so are their workers. And so work arrangements become more precarious, risk is shifted onto the smaller employers, and they're often cast in the role of an independent contractor. And Anne-Marie's talk explains very well the kinds of problems that can arise from a work health and safety perspective. Why is supply chains problematic from a work health and safety perspective? Because they create greater insecurity, job insecurity, poorer pay, reduced access to training, less control over working time, and inadequate participation in work health and safety. And that in turn leads to an increased incidence of cardiovascular disease, burnout, depression, and poorer safety outcomes. And I've referred to the two industries with examples of those issues, but I won't go through them because I just don't have time. And the last thing I want to say before I talk about law, which we're all here for, I'm sure, is why do supply chains lead to poor work health and safety outcomes? And I'm just reminding people of the Queensland et al. Model of the PDR model, pressure, disorganisation and regulatory failure. So the same competitive pressures that drive people into using fissured arrangements also has severe negative impacts on health and safety. The slide gives the details, but I just want to make that point. Those kinds of work arrangements are fractured, and it's the fracturing and disorganisation of those work arrangements that themselves lead to problems for health and safety. And again, the details are all on the slide. And the R in the PDR model is regulation. Regulation generally is not suited to regulate this form of work arrangement. And again, Anne-Marie's paper gave you a masterclass in the problems that arise. Okay, now from about the early 1990s, Australia, which is the Australian work health and safety legislation is generally found at state and territory level for constitutional reasons. Nobody wants me to explain the Constitution, so take it from me that that's the arrangement. And so what's happened over the years is that each statute is quite different and has different provisions, and I'm sure that's the same in Canada. So from about 1991, but particularly from about 2008, there was a huge effort to harmonise the work health and safety legislation. And there's a national review panel put together in 2008, and it examined each of the statutes and looked for good practice, best practice, and so on. And one of the things it was asked to take into account was the changing nature of work and employment relationships. So people always ask me, why did this come about? One of the reasons was that this was an issue on the agenda, and that the review committee was expressly asked to look at changing work arrangements. The result was a Work Health and Safety Act. That's why I'm using the term rather than Occupational Health and Safety. And the key provision in the Work Health and Safety Act is the provision that Anne-Marie foreshadowed. So the main duty, the primary duty of care, is owed not by an employer, but if you look at the PowerPoint, it's owed by a person who conducts a business or an undertaking. And that's very broadly defined. The whole idea is it should cover anybody who is a provider of work. And the duty is to ensure, so far as is reasonably practicable, the health and safety of workers engaged or caused to be engaged by the person conducting the business or undertaking, which I'm affectionately going to refer to now, from now on, as a PCBU. And the duty is also owed to workers whose activities in carrying out work are influenced or directed by the PCBU. Now, the most important thing to say about that, there are two things. One is that there doesn't have to be a direct contractual relationship of any kind in that definition. And the second thing is that workers are very broadly defined. A worker is anybody who carries out work for the PCBU. Now, when I teach this, people raise up their hands and say, would that cover? And before they finish, I say yes. I've never been in a situation yet when the answer has actually been no. And when it does, of course, I'll pretend that it is, that I didn't understand the question. Now, even if the answer is no, have a look at section 19(2). A PCBU must ensure, so far as reasonably practicable, that the health and safety of other persons is not put at risk from work carried out. So even if miraculously a worker was not a worker within section 19(1), the duty is still owed to the worker in section 19(2). Now, the consequence of that is that each retailer, fashion house, transport operator, contractor, etc., that you saw in my previous pictures, owes a duty to all workers below it or them in the supply chain. So the retailer owes a duty to all workers below it in the chain. The contractor does the same, the subcontractor the same. And what it means is that it's very difficult to owe a duty if you don't know of the existence of the person. So in a sense, it's also imposing an obligation to find out, and I'll reinforce that point in a moment. We've also revolutionized our officer's duty. Each officer owes a positive and proactive duty to exercise due diligence to ensure that the PCBU complies with its duty under the Act. Good, 10, I can do that. Officer includes the usual people that you'd expect, but there's a broader definition to include others, persons who make or participate in making decisions that affect the whole or a substantial part of the business of the corporation. So this is a very far-reaching duty on each officer, each one. You can't say, well, somebody else knows about it. Michael Quinlan knows about health and safety. I don't have to know anything about it. That's what I usually do. Each officer owes the duty, and it's proactive and positive. So each officer within the lead organisation, for example, needs to know about the supply chain, what it looks like, and the hazards and the issues arising from the chain. The third key provision is Section 46, which I think Anne-Marie referred to. It says if more than one person has the same duty concurrently under this Act, so if more than one person has the Section 19(1) duty, each person with the duty must, so far as reasonably practicable, consult, cooperate and coordinate activities with all other persons who have a duty in relation to the same matter. And there's a code of practice which explains that a PCBU in a supply chain, for example, can't assume that other people will look after workers in the chain. They have to find out who else is working, who else is running a business, and then they need to cooperate and coordinate and consult in implementing the duty. And you can see what a significant impact that has on supply chain regulation. Quickly, but without annoying the interpreters, I just want to run through three other provisions that are really important. There's a duty to consult. We call this the vertical duty. There's a duty on each PCBU to consult all of the workers that carry out work for the PCBU about health and safety, to the extent that that's possible, feasible. Okay, that might be really difficult in some arrangements. So the PCBU must consult with all workers below the PCBU in the supply chain. Next, there's basically all of our work arrangements in relation to health and safety representatives are not built around the employment paradigm, but around the PCBU and workers. So I won't go through that PowerPoint in detail, but the result is that health and safety representatives represent all workers. It doesn't matter if they're employees or any other kind of worker, as long as they were within the work group that elected the health and safety representative. And finally, unions have union entry provisions to inspect suspected contraventions of the work health and safety legislation. I've summarised very nicely for you on the PowerPoint the combined effect of these provisions, but I haven't got time to explain them. Now, how are these enforced? And the short answer is I've done a fair amount of research on this, and to be really frank, the work health and safety regulators haven't really thought about the way they're going to use these powers in relation to supply chains, but I'm happy to explain that in much greater detail in a question later. The regulators have a whole range of enforcement powers, and again, I don't have time to explain those in great detail, but they're the usual things. Informal enforcement methods, advise, persuade, statutory notices, improvement, prohibition, and so on. Prosecution, and our fines have been increased to about $3 million for and Canadian dollars roughly the same as an Australian dollar, although I'd rather have a Canadian dollar than an Australian dollar. And then we've also got enforceable undertakings, which is an arrangement where the person alleged to have contravened a provision can make an offer to the regulator to do something about health and safety, and I'll come back to that. Okay, so we don't really have an approach. What should we do? And what I want to do for the remainder of my time, which may involve staring down the chair if I run out, is to talk about David Weil's approach, strategic enforcement approach, which has been designed for labour regulation and particularly for fissured work arrangements, which I explained earlier. So whereas traditional enforcement focuses on changing behaviour of the direct employer in relation to the employee, fissured work arrangements, the strategic enforcement approach is much more strategic. It focuses on the underlying factors that get in the way of compliance, and it's about changing the behaviour of the lead firms at the top of the arrangement rather than focusing on the bottom. 5. Okay. So I've got 8 PowerPoints to cover in 5 minutes, and this is how I'm going to do it. There are 4 criteria involved in strategic enforcement. 1, prioritization. So the first strategic aspect of strategic enforcement is to conduct a kind of a risk analysis, but the risk analysis really involves in focusing on sectors that have high violations, high contraventions, where there are large concentrations of vulnerable workers, but workers who are not in a position to complain to the regulator, and where regulatory intervention is likely to be successful in changing compliance behaviour in a whole sector or geographical region. The second is the importance of deterrence. Now, lovers of responsive regulation will know that deterrence slips into the background in the enforcement model. But in the strategic enforcement model, it's up front and centre. But it's not just specific deterrence, it's general deterrence. It's about trying to bring about ripple effects within the supply chain, within the industry, across lead businesses, and in geographic areas. The third aspect is that the regulator must think about getting sustainable and ongoing compliance. So the strategy should be to avoid recidivism. I shouldn't have put that up because I knew I wouldn't be able to pronounce it. Should aim for sustainable and ongoing compliance across industry, not just within the supply chain. And the fourth basic principle is that the regulator should aim for systemic effects. So should understand the drivers of non-compliance within the industry or sector, not just within the firm. So must look for the root causes of non-compliance, and they must try and alter system-wide the way that the system works. Okay, so this is what I would do if suddenly I found myself, like David Weil, running the regulator. Need to focus at the top of the industry structure. So inspection activity, investigation activity, enforcement activity must be aimed at the lead firms at the top of the supply chain. And you'll see that the Section 19 PCBU's duty is ideal for that, as is the officer's duty. So that could be a focus of that kind of activity. So any investigation procedure should be aimed strategically at the key lead firms within the industry. Not randoms, but the key ones. Oops, I knew I would drive badly. Help. Okay, I haven't got time, so I'm going to just use my own notes. Is it fixed? Okay. Secondly, the aim should be to enhance ripple effects, to really make deterrence front and centre. So you'll see from the previous slides that the work health and safety legislation has very high fines. Those should be front and centre. Prosecution should be targeted very carefully at the top of the supply chain, not at the bottom. And whatever happens, deterrence should be spread by publicising on websites, by spreading it through workers' groups and through industry groups. So the idea is to spread the word, particularly within the industry or the geographical area. The third is to use complaints differently. So the way the regulators currently use complaints is to stare at them for a while and then decide if they're really serious and should be investigated, or whether they're less serious and should be the subject of a phone call or perhaps a quick visit. Whereas David Weil points out that that complaints should be nested within a larger universe of workplace problems faced by the agency. So complaints are very useful information. In fact, asking questions about what led to the complaint yields very useful information. If that's supplemented by talking to unions and other strategic players and other people who understand the way that the industry works or the geographical area works, then complaints can be used more proactively to develop strategic programs. And the final point is to enhance the sustainability of initiatives through monitoring. 1 minute, I can do it. Enhance the sustainability of initiatives through monitoring and related procedures. So similar to responsive regulation, strategic enforcement envisages creating new monitoring arrangements where you draw upon non-state actors to monitor what's going on in the supply chain and to provide information not just about contravention but to spread information about best practice as well. And the second thing is to develop tools, and David Weil talks about comprehensive settlement agreements to improve system-wide compliance. And this is where those enforceable undertakings are potentially very useful, because the enforceable undertaking can be imposed upon the lead business at the top of the supply chain, and that business might have to undertake additional obligations, volunteers these, that you won't find in the legislation, but something about having a hotline if there are complaints about health and safety, and then undertaking to deal with the complaints quickly and then reporting the consequences and the settlement achieved in the complaint to the regulator. And I won't actually make the point about proactive compliance deeds in much detail because I can feel the chair is about to jump up and pull me down. But the point about that is that you can actually develop common law contracts or deeds that can do more than enforceable undertakings, because it's not contingent, as enforceable undertakings are, on there being a contravention before you can come to some kind of arrangement. So, for example, if you're in a supply chain and the contravention is by the lead business, but you actually want to clean up the supply chain by engaging others in a partnership with the regulator, you can use proactive compliance deeds to negotiate with those other parties to get them to do key things to make compliance long-term and sustainable. Thank you.